Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Criminal Conspiracy Lawyer, Chicago, Illinois. Facing a criminal conspiracy charge in Chicago, Illinois can be overwhelming, especially given how complex these cases tend to be. Unlike other criminal charges, conspiracy allegations involve multiple people, extensive evidence, and detailed investigations into intent and agreement, making them particularly challenging to defend against. Depending on the circumstances, the penalties for a conspiracy conviction can vary widely, ranging from relatively minor consequences to severe felony charges carrying significant prison time and long-term impacts on your future. If you've been accused of criminal conspiracy in Chicago or Cook County, it's critical to act quickly. The experienced criminal defense lawyers at Combs Waterkotte understand how to navigate the intricacies of these cases and build a strong defense tailored to your situation. Don't face these complicated charges alone. Get the legal support you need to protect your rights and your future. Criminal conspiracy lawyer in Chicago, Illinois, serving all of Cook County. Criminal conspiracy charges in Chicago and throughout Cook County are not something you should take lightly. These cases are often built on complex allegations involving multiple parties, detailed evidence, and aggressive prosecution strategies. A conviction can lead to serious consequences, including fines, probation, or significant prison time, depending on the severity of the alleged offense. Trying to handle a conspiracy charge on your own can put your future at even greater risk. At Combs Waterkotte, we bring over 8 decades of combined experience to defending clients against complex criminal charges like conspiracy. Our legal team understands how Cook County prosecutors build these cases, and we know where to look for weaknesses. From challenging the existence of an alleged agreement to questioning the credibility of witnesses and evidence, we take a strategic, detail-oriented approach to every criminal conspiracy case. When you choose our firm, you receive a defense strategy tailored specifically to your circumstances. We take the time to understand your side of the story, analyze every piece of evidence, and identify opportunities to have your charges reduced or dismissed. Our attorneys are skilled negotiators, but we also prepare every case as if it's going to trial, ensuring you're fully protected at every stage of the legal process. If you're ready to fight back against your criminal conspiracy charges in Chicago or anywhere in Cook County, Combs Waterkotte is here to help. We're committed to protecting your rights, reputation, and future. Call us today at 312-500-HELP or reach out online to get started with a free, confidential consultation. What is a criminal conspiracy in Chicago, Illinois? Conspiracy charges in Chicago and Cook County are complex and involve multiple layers. Under Illinois law, conspiracy is considered an inchoate offense, a crime that wasn't completed, but that individuals did take steps toward committing. The actual law outlining what constitutes a conspiracy falls under 720 ILCS 5/8-2. The statute says someone can be charged with a conspiracy when a defendant, or more commonly, multiple defendants, has real intent to commit a crime, agrees with another defendant or defendants to commit a crime, commits an overt act in furtherance of committing the crime. It does not matter who commits this overt act. If one person involved in the conspiracy does so, each member involved can be charged. The overt act requirement is relatively uncommon. Illinois is one of a few states that require this level of evidence in conspiracy cases. The requirement of an overt act means that merely discussing or planning a crime isn't enough. Someone involved in the conspiracy must take real action in an attempt to carry out the conspiracy. Examples of overt acts include buying supplies in drug conspiracy cases, for example, traveling to the crime scene, sending coordinating messages to conspirators, conducting surveillance around the area of the crime. While the overt act requirement sets a relatively high bar for prosecutors to try defendants with conspiracy, it's much easier under the law to prove an agreement. Illinois law maintains that formal or explicit agreements in conspiracy cases are not required, but rather, agreement can be inferred from conduct. Circumstantial evidence is enough to prove an agreement. The parties involved in the conspiracy don't have to meet face-to-face to constitute an agreement. Common Chicago, Illinois criminal conspiracy charges. While a conspiracy charge may essentially be brought against any criminal conspiracy in Chicago or Cook County, area prosecutors bring conspiracy charges against certain offenses more often than others. Chicago conspiracy charges commonly arise in drug trafficking cases, gun possession cases, organized retail theft rings, fraud schemes like identity theft or insurance fraud. Criminal conspiracy charges are used to target groups of individuals involved in a network of criminal activity. In some cases, Illinois law even outlines specific conspiracy-related offenses. Some of them include calculated criminal drug conspiracy, charged against drug rings that profit at least $500 from trading controlled substances, street gang criminal drug conspiracy, brought against drug dealers who are members of a gang, insurance fraud conspiracy, levied against groups who gain payouts from insurance companies by making false claims. While the laws around criminal conspiracy in Chicago are complex, and the kinds of offenses that constitute conspiracy vary widely, the penalties for conspiracy offenses are just as varied and complicated. What are the penalties for criminal conspiracy in Chicago, Illinois? Before considering the actual penalties for a Chicago conspiracy conviction, it's important to understand some of the circumstances that can leave an individual vulnerable to those penalties. Illinois' conspiracy law says it is not a valid defense for a defendant to assert that one of their co-conspirators has not been prosecuted or convicted for the conspiracy, has been convicted of a different offense other than the conspiracy, is not able to be charged in the conspiracy because they are an undercover police officer, a confidential informant, a minor, outside of the court's jurisdiction, deceased, has been acquitted of the conspiracy charges, lacked the capacity to commit the underlying offense. Under the law, even if any of those things are true about one or all of your co-conspirators, you can still be charged with conspiracy. When it comes to penalties, Illinois uses the one-step-down approach for criminal conspiracy sentencing. In other words, if you plan to commit a Class 10 felony offense, you're charged with a Class 1 felony. If you plan to commit a Class 1 felony offense, you're charged with a Class 2 felony. If you plan to commit a Class 2 felony offense, you're charged with a Class 3 felony. If you plan to commit a Class 3 felony offense, you're charged with a Class 4 felony. Conspiracy to commit a Class 4 felony offense is the exception to this rule. If you're convicted for conspiracy to commit a Class 4 felony in Chicago, you'll be subject to the full Class 4 felony sentencing guidelines. The offense is not reduced to a misdemeanor. Misdemeanors are handled the same way. If you're convicted for conspiracy to commit a Class A misdemeanor in Chicago or Cook County, you'll be subject to the full Class A misdemeanor sentencing guidelines, i.e., up to 1 year in jail and a fine up to $2,500. There are some specific exceptions in the Illinois conspiracy statute to the one-step-down sentencing rule. Below is an exhaustive list of those exceptions. Offenders receive automatic Class 10 felony sentencing for conspiracy to commit aggravated insurance fraud, when the person is an organizer of the conspiracy. Aggravated governmental entity insurance fraud, when the person is an organizer of the conspiracy. Offenders receive automatic Class 1 felony sentencing for conspiracy to commit first-degree murder, aggravated insurance fraud, aggravated governmental insurance fraud. Offenders receive automatic Class 2 felony sentencing for conspiracy to commit insurance fraud, conspiracy to commit governmental entity insurance fraud. Offenders receive automatic Class 3 felony sentencing for conspiracy to commit solicitation of a prostitute, promotion of prostitution, keeping a place of prostitution, unlawful possession of weapons under 720 ILCS 5/24-1A1 and 720 ILCS 5/24-1A7. Gambling, keeping a place of gambling. Registration of federal gambling stamps violations. Look-alike substance violations. Miscellaneous controlled substance violations under 720 ILCS 570/406B. Criminal defense strategies against Chicago criminal conspiracy charges. Due to the severity and complexity of Chicago conspiracy charges, it's important to retain a criminal defense lawyer if you're charged. They can formulate effective criminal defense strategies against these charges, like the ones outlined here. Challenging the existence of an agreement. One of the most effective defenses against Chicago conspiracy charges is arguing that no true agreement ever existed. In Illinois, conspiracy requires proof of an agreement, not just association or parallel conduct. In Cook County cases, prosecutors often rely on text messages or proximity to others. A defense attorney can argue that those communications were misinterpreted or unrelated. For example, being present during a drug transaction does not automatically prove you agreed to participate in a criminal plan. Lack of criminal intent. Cook County conspiracy charges require intent that a crime be committed. If a defendant lacks that intent, the charge cannot stand. In practice, Chicago prosecutors may infer intent from circumstantial evidence like coded messages or behavior. A defense strategy may focus on innocent explanations like misunderstanding a conversation or being unaware of illegal activity. For instance, if a rideshare driver unknowingly transports individuals involved in a crime, they can't be charged with conspiracy. No overt act in furtherance of the conspiracy. Illinois law specifically requires proof that at least one conspirator committed an overt act to advance the alleged agreement. Defense attorneys often attack whether this element exists. In Cook County courts, prosecutors may point to minor acts like traveling or making a phone call, but the defense can argue these actions were not tied to any criminal objective. Without a clear step toward committing the offense, a conspiracy charge may fail. Entrapment by law enforcement. Entrapment is a powerful defense in Chicago conspiracy cases involving undercover operations. If law enforcement induced someone to commit a crime they otherwise would not have engaged in, a conspiracy charge may be invalid. In Chicago drug sting cases, officers or informants may initiate contact and encourage illegal conduct. A defense attorney can argue the defendant was not predisposed to commit the offense and was pressured into agreeing to a plan, potentially nullifying conspiracy charges. Fourth Amendment violations for illegal search and seizure. Conspiracy cases in Chicago and Cook County tend to rely heavily on digital evidence, surveillance, or seized property. If police obtained this evidence through an unlawful search, it may be suppressed. In Cook County, This frequently arises in cases involving cell phone data or vehicle searches. A defense attorney can challenge whether officers had a valid warrant or probable cause, and if key evidence is excluded, the prosecution may no longer be able to prove the alleged agreement. Fifth Amendment and Miranda rights violations. Statements made during a CPD interrogation can play a central role in conspiracy prosecutions. If a defendant was not properly advised of their Miranda rights or was coerced into speaking, those statements may be inadmissible. In Chicago cases, this can occur during lengthy police questioning. A defense attorney can file a motion to suppress these statements, weakening the state's case, especially where the alleged conspiracy relies heavily on the defendant's own words. Withdrawal from the conspiracy. Illinois law recognizes that a person can withdraw from a conspiracy under certain circumstances. To be effective, the withdrawal must typically occur before any overt act and must be communicated clearly to co-conspirators. In practice, this might involve a defendant backing out of a plan and telling their co-conspirators of their intent not to participate. In a Chicago fraud case, for example, showing that the defendant refused to participate further and distanced themselves could help defeat liability. Duress or coercion. A defendant in a Chicago conspiracy case may argue that they only agreed to participate in a conspiracy because of threats or coercion. This defense requires showing a reasonable fear of imminent harm and no realistic opportunity to escape the situation. In Cook County criminal conspiracy cases, this can arise in gang-related prosecutions where individuals claim they were pressured into involvement. A defense attorney can present evidence of threats or intimidation to show the agreement was not truly voluntary. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.